Everyone, today we are going to discuss about the Code of Criminal Procedure 1898. So let's start. Chapter 1, Short Title and Commencement. This act may be called the Code of Criminal Procedure 1898 and it shall come into force on the day of July 1898. Extent. It extends to the whole of Bangladesh, but in the absence of any specific provision to the contrary, nothing herein contained shall affect any special law now in force, or any special jurisdiction or power conferred, or any special form of procedure prescribed by any other law for the time being in force. Repealed. Repealed by the Repealing and Amending Act 1914, Act number X of 1914. Omitted. Omitted by Section 3 and 2nd Schedule of the Bangladesh Laws Revision and Declaration Act 1973, Act number V3 of 1973. Expressions in former acts. In every enactment passed before this court comes into force, the expression officer exercising or having the powers or the full powers of a magistrate, subordinate magistrate first class and subordinate magistrate second class shall respectively be deemed to mean magistrate of the first class, magistrate of the second class and magistrate of the third class. The expression magistrate of the district shall be deemed to mean district magistrate. Definitions. In this code, the following words and expressions have the following meanings unless a different intention appears from the subject or context. Advocate used with the reference to any proceeding in any court means an advocate or a mukhtar authorized under any law for the time being in force to practice in any such court, and includes any other person appointed with the permission of the court to act in such proceeding. Attorney General means the Attorney General for Bangladesh and includes also the Additional Attorney General, the Deputy Attorney General or the Assistant Attorney General for Bangladesh, or a government advocate or such officer as the government may from time to time appoint in this behalf. Bailable offense means an offense shown as bailable in the second schedule or which is made bailable by any other law for the time being in force, and non-bailable offense means any other offense. Charge includes any head of charge when the charge contains more heads than one. Repealed by Section 3 and Schedule 2 of the Repealing Amending Act 1923, Act number XI of 1923. Clerk of the State includes any officer specially appointed by the Chief Justice to discharge the functions given by this court to the Clerk of the State. Cognizable offense means an offense for an cognizable case means a case in which a police officer may, in accordance with the second schedule of under any law for the time being in force, arrest without warrant. Omitted by the Schedule of the Adoption of Central Acts and Ordinances Order 1949. Complaint means the allegation made orally or in writing to magistrate with a view to his taking action under this code that some person, either known or unknown, has committed an offence, but it does not include the report of a police officer. Court of Section includes the Metropolitan Court of Session. Omitted by the Schedule of the Criminal Law Extinction of Discriminatory Privileges Act 1949, Act number 2 of 1950. High Court Division means the High Court Division for Criminal Appeal or Revision. Inquiry includes every inquiry other than a trial conducted under this code by magistrate or court. Investigation includes all the proceedings under this code for the collection of evidence conducted by a police officer or by any person other than a magistrate who is authorized by magistrate in this behalf. Juridical proceeding includes any proceeding in the course of which evidence is or may be legally taken on oath. Non-cognizable offense means an offense for a non-cognizable case means a case in which a police officer may not arrest without warrant. Offense means any act or omission made punishable by any law for the time being in force. It also includes any act in respect of which a complaint may be made under Section 20 of the Cattle Trespass Act 1871. Officer in charge of police station includes when the other officer in charge of the police station is absent from the station house or unable from illness or other cause to perform his duties. The police officer present at the station house who is next in rank to such officer and is above the rank of constable, or when the government so directs any other police officer so present. Place includes also house, building, tent and vessel. Permitted by Section 3 and 2nd Schedule of the Bangladesh Laws Revision and Declaration Act 1973, Act number V3 of 1973. Police station means any post or place declared generally or especially by the government to be a police station and includes any local area specified by the government in this behalf. Public prosecutor means any person appointed under Section 492 and includes any person acting under the directions of public prosecutor. Upazila means Upazila defined in the Upazila Parishad Act 1998, Act number 24 of 1998. V and W made by Section 2 of the Code of Criminal Procedure, Second Amendment, Ordinance 1982, Ordinance number XXIV of 1982. Words of referring to acts. Words which refer to acts done extend also to illegal omissions and was to have some meaning as in penal code. All words and expressions used herein and defined in the penal code and not herein before defined shall be deemed to have the meanings respectively attributed to them by that code. Construction of references. In this code, unless the context otherwise requires any reference without any qualifying word to a magistrate, shall be constructed as a reference to a judicial magistrate, with a qualifying word not being a word clearly indicating a judicial magistrate shall be constructed as a reference to a magistrate as indicated in subsection 2b. To a subdivisional magistrate shall be constructed as a reference to the district magistrate if the functions accessible are of the nature specified in clause of subsection 2, the chief judicial magistrate, or as the case may be the chief metropolitan magistrate if the functions accessible are of the nature specified in clause A of subsection 2. To an assistant sessions judge shall be constructed as a reference to a joint sessions judge. To any area which is included in a metropolitan area shall be constructed as a reference to such metropolitan area. To any reference to a magistrate of the first, second or third class in relation to an area which is included in metropolitan area shall be constructed as a reference to the metropolitan magistrate exercising jurisdiction in that area. To a magistrate of the first, second or third class in relation to an area outside a metropolitan area shall be constructed as a referee to a judicial magistrate of the first, second or third class exercising jurisdiction in that area. Where under any law for the time being in force other than this code, the functions accessible by a magistrate related to matters which involve the appreciation or shifting of evidence or the formulation of any decision which exposes any person to any punishment or penalty of detention in custody pending investigation, inquiry or trial or other proceedings, or would have the effect of sending him for trial before any court, they shall subject to the provision of the code the accessible by a judicial magistrate, or which are administrative or executive in nature, such as the granting of a license, the suspension or cancellation of a license, sanctioning or prosecution or withdrawing from a prosecution, they shall subject as aforesaid by accessible by an executive magistrate. Trial offences under penal code. All offences under the penal code shall be investigated, inquired into, tried and otherwise dealt with according to the provisions herein after contained. Trial of offences against other laws. All offences under any other law shall be investigated, inquired into, tried and otherwise dealt with according to the same provisions, but subject to any enactment for the time being in force regulating the manner of place, investigating, inquiring into, trying, otherwise dealing with such offences. Chapter 2 of the Constitution of Criminal Courts and Offices. Classes of criminal courts. Besides the Supreme Court and the courts constituted under law for the time being in force other than this court, there shall be two classes of criminal Bangladesh, namely courts of sessions and courts of magistrates. There shall be two classes of magistrate, namely judicial magistrate and executive magistrate. There shall be four classes of judicial magistrate, namely Chief Metropolitan Magistrate in Metropolitan area and Chief Judicial Magistrate to other areas. Magistrate of the first class who shall in Metropolitan area be known as Metropolitan Magistrate. Magistrate of the second class and Magistrate of the third class. Explanation. For the purpose of this subsection, the word Chief Metropolitan Magistrate and Chief Judicial Magistrate shall include additional Chief Metropolitan Magistrate and additional Chief Judicial Magistrate respectively. Sessions, divisions and districts. Bangladesh shall consist of sessions, divisions, and every sessions division shall, for the purposes of this code, be a district or consist of districts. Power to alter divisions and districts. The government may alter the limits or the number of such divisions and districts. Existing divisions and districts maintained till altered. The sessions, divisions and districts existing when this court comes into force shall be sessions, divisions and districts respectively unless and until they are so altered. A metropolitan area shall for the purposes of this code be deemed to be sessions division. Existing subdivisions, power of divide districts into upazilas, etc. The government may divide a district into upazilas and by notification in the official gazette fix or alter the limits of upazila or merge the area of more than one upazila into one upazila, and is in so fixing, altering or merging, the government shall ensure the area of upazila is identical with the local area included in a police station. Existing subdivisions maintained. All existing subdivisions which are now usually put under the charge of a magistrate shall be deemed to have been made under this code. Court of Sessions. The government shall establish a court of session for every sessions division and appoint a judge of such court, and the court of session for a metropolitan area shall be called the Metropolitan Court of Session. The government may be general or special order in the official gazette direct at what place or place the court of session shall hold its sitting, but until such order is made, the courts of session shall hold their sittings as heretofore. The government may also appoint additional sessions judge and assistant session judges to exercise jurisdiction in one or more such courts. The members of a Bangladesh Judicial Service shall be appointed as session judge, additional session judge and joint session judge in accordance with the rules framed by the President under the proviso to Article 133 of the Constitution to exercise jurisdiction in one or more of such areas. A sessions judge of any sessions division may be appointed by the government to be also an additional session judge of another division, and in such case he may sit for the disposal of cases at such place or places in either divisions as the government may direct. He may sit for disposal of cases at such place in the divisions the government may direct. All courts of session existing when this court comes into force shall be deemed to have been established under this Act. Executive Magistrates. In every district and in every metropolitan area, the government shall appoint as many persons as it thinks fit to be executive magistrates, and shall appoint one of them to be the district magistrate. The government may also appoint any executive magistrate to be an additional district magistrate, and such additional district magistrate shall have all or any of the powers of district magistrate under this code or under any other law for the time being in force as the government may direct. Whenever in consequence of the office of a district magistrate becoming vacant any other officer succeeds temporarily to be the chief executive in the administration of the district, such officers shall, pending to the others of the government, exercise all the powers and perform all the duties respectively conferred and imposed by this code on the district magistrate. The government may, or subject to the control of the government, the district magistrate may from time to time by order define local areas within which the executive magistrate may exercise all or any of the powers with which they may be invested under this code, and except as otherwise provided by such definition, the jurisdiction and powers of every such executive magistrate shall extend throughout the district. The government may, if it thinks expedient or necessary, appointment any persons employed in the Bangladesh Civil Service Administration to be an executive magistrate, and the confirm the powers of an executive magistrate on any such member. Subject to the definition of the local areas under subsection 4, all persons appointed as assistant commissioners, additional deputy commissioners or Upajela Nirbhahi officer in any district or Upajela shall be executive magistrates and may exercise the power of executive magistrate within their existing respective local areas. Nothing in this section shall preclude the government from conferring under any law for the time in force on a commissioner of police all or any of the power of an executive magistrate in relation to a metropolitan area. Judicial magistrates. In every district outside a metropolitan area, the chief judicial magistrate, additional chief judicial magistrates, and other judicial magistrates shall be appointed from the persons employed in the Bangladesh Judicial Service in accordance with the rules framed by the President under the provision 2, Article 133 of the Constitution. An additional chief judicial magistrate shall have all or any of the powers of the chief judicial magistrate under this code or any other law for the time being in force, as the government may direct. The government may, by general or special order in the official gazette, direct at what place or places the court of chief judicial magistrate, additional chief judicial magistrate, and other judicial magistrates shall hold its sitting. The government may, or subject to the general for special orders issued by the government in consultation with the High Court Division, the chief judicial magistrate may from time to time define local areas within which the judicial magistrates may exercise all or any of the powers with which they may be invested under this code, and except as otherwise provided by such definition, the jurisdiction and powers of every such magistrate shall extend throughout the district. Notwithstanding anything contained in this section, the government may require any executive magistrate to perform the functions of a judicial magistrate for a period to be determined in consultation with the High Court Division, and during such period the magistrate shall not perform the functions of an executive magistrate. Special magistrate. The government may confer upon any person or all or any of the powers conferred or conferable by or under this code on an executive magistrate in respect of particular cases or a particular class or classes of cases, or in regard to cases generally in any local area outside a metropolitan area, provided that no power shall be conferred under the subsection or any police officer below the grade of an assistant superintendent of police, and no powers shall be conferred on such police officer except so far as may be necessary for preserving the peace, preventing crime, and detecting, apprehending, and detaining offenders, in order to bring the offenders before a magistrate, and for the performance by the officer of any other duties imposed upon him by any law for the time being in force. The persons on whom the power under subsection 1 are conferred shall be called special executive magistrates, and shall be appointed for such term as the government may general or special order direct. The government may, in consultation with the High Court Division, confer upon any magistrate all or any of the powers conferred or conferable by or under this code on a judicial magistrate of the first, second, or third class in respect of particular cases or a particular class or classes of cases, or in regard to cases generally in any local area outside a metropolitan area. The magistrate on whom the powers under subsection 3 are conferred shall be called special magistrates, and shall be appointed for such terms as the government may, in consultation with the High Court Division, by general or special order direct. The government may, in consultation with the High Court Division, confer upon any metropolitan magistrate all or any of the powers conferred or conferable by or under this code on Metropolitan Magistrate in respect of particular cases or a particular class or classes, or in regard to cases generally in any metropolitan area, the persons on whom the powers under subsection 5 are conferred shall be called special metropolitan magistrates and shall be appointed for such terms as the government may in consultation with High Court division by the general or special order direct. Benches of magistrates. The government may direct any two or more magistrates in any place outside metropolitan area to sit together as a bench and may by order invest such bench with any of the powers conferred or conferable by or under this code on a magistrate of the first, second or third class and direct it to exercise such powers in such cases or such classes of cases only and within such local limits as the government thinks fit. Powers exercisable by bench in absence of special direction. Except as otherwise provided by any order under this section, every such bench shall have the powers conferred by this code on a magistrate of the highest class to which any one of its members who is present taking part in any proceedings as a member of the bench belongs, and as far as practicable shall for the purposes of this code be deemed to be a magistrate of such class. Power to frame rules for guidance of benches. The government may, or subject to the control of the government, the may from time to time makes rules consistent with this code for the guidance of magistrates benches in any district respecting the following subjects: the classes of cases to be tried, the times of places of sitting, the constitution of the bench for conducting trials, the mode of setting differences of opinion which may arise between the magistrates in session. Subordination of executive, judicial and metropolitan magistrates. All executive magistrates appointed under section 10 and 12 shall be subordinate to the district magistrate, who from time to time give a special order consistent with this code as to the distribution of business among such magistrates. All judicial magistrates appointed under section 11 and 12 and all benches constituted under section 15 shall be subordinate to the chief judicial magistrate, who may from time to time give special orders consistent with this code and rules made by the government under section 16 as to the distribution of business among magistrates and benches. All metropolitan magistrates include additional chief metropolitan magistrate and special metropolitan magistrate appointed under section 12(5) and benches constituted under section 19 shall be subordinate to the chief metropolitan magistrate, who may from time to time give special orders consistent with this code and rules made by the government under section 16 as to the distribution of business among such magistrates and benches. All judicial magistrates include the chief judicial magistrate shall be subordinate to the sessions judge, and all metropolitan magistrates including the chief metropolitan magistrate shall be subordinate to the metropolitan sessions judge. Subordinate of joint session judges. All joint session judges shall be subordinate to the session judge in whose court they exercise jurisdiction, and session judge may from time to time make rules or give special orders consistent with this code as distribution of business among such joint session judges. The session judges may also, when he himself is unavoidably absent or incapable of acting, make provision for the disposal of any urgent application by an additional or joint session judge, and such judge shall have jurisdiction to deal with any such application. Appointment of metropolitan magistrates. In every metropolitan area, the chief metropolitan magistrate, additional chief metropolitan magistrate, and other metropolitan magistrates shall be appointed from among the persons employed in the Bangladesh Judicial Service. The government may appoint one or more additional chief metropolitan magistrates, and such additional chief metropolitan magistrates shall have all or any of the powers of the chief metropolitan magistrates under this code or under any other law for the time being in force as the government may direct. Benches. Any two or more of Metropolitan magistrates may, subject to the rules made by the Chief Metropolitan Magistrate, sit together as bench. Local limits of jurisdiction. Every Metropolitan Magistrate shall exercise jurisdiction in all places within Metropolitan area for which he is appointed. Chief Metropolitan Magistrate. The Chief Metropolitan Magistrate shall exercise within the local limits of his jurisdiction all the powers conferred on him or on a Metropolitan Magistrate under this code or under any law for the time being in force, and may from time to time with the provision sanction of the government make rules consistent with this code to regulate the conduct and distribution of business and the practice in the courts of Metropolitan Magistrates, the constitution of benches of Metropolitan Magistrates, the times and places at which such benches shall sit, the mode of setting differences of appointing which may arise between Metropolitan Magistrates in sessions, and any other matter which could be dealt with by a Chief Judicial Magistrate under his general powers of control over the magistrates subordinate to him. Justice of the peace for the Mafasal. The government may by notification in the official gazette appoint such persons resident within Bangladesh and not being the subjects of any foreign states as it thinks fit to be justice of the peace within and for the local area mentioned in such notification. Repealed. 23 and 24 repealed by Section 4 of the Criminal Law Amendment Act 1923, Act number XII of 1923. Ex officio justices of the peace. In virtue of the respective offices, the judge of the Supreme Court are justices of the peace within and for of the whole of Bangladesh. Session judges, Chief Judicial Magistrate and Metropolitan Magistrates are justices of the peace within their respective jurisdictions. Chapter 3. Power of Courts. Offences under Penal Code. Subject to the other provisions of this code, any offences under the Penal Code may be tried by the High Court Division or by the Court of Session or by any other court by which such offence is shown in the 8th column of the second schedule to be triable. Illustration: A is tried by the Sessions Court on a charge of culpable homicide. He may be convicted of voluntarily causing hurt, an offence triable by a magistrate. Offences under other laws. Subject to the other provisions of this code, an offence under any other law shall, when any court is mentioned in this behalf in such law, be tried by such court. When no court is so mentioned, it may be tried, subject as aforesaid, by any court constituted under this code by which such offence is shown in the 8th column of the second schedule, so be triable. Omitted. Omitted by the Criminal Law Extinction of Discriminatory Privileges Act 1949, Act number 2 of 1950. Jurisdiction in the cases of juveniles. Any offence other than one punishable with death or transportation for life committed by any person who at the date when he appears or is brought before the court is under the age of 15 years may be tried Chief Judicial Magistrate or the Chief Metropolitan Magistrate or by any magistrate especially empowered by the government to exercise the powers conferred or any under any law providing for the custody, trial or punishment of youthful offenders by any magistrate empowered by under such law to exercise all or any of the powers conferred thereby. Offences not punishable with death. Notwithstanding anything contained in section 29, the government may, in constitution with the High Court division, invest the Chief Metropolitan Magistrate, Chief Judicial Magistrate, or any additional Chief Judicial Magistrate with power to try as a magistrate all offences not punishable with death. Invest Metropolitan Magistrate or any magistrate of the first class with power to try as a magistrate all offences not punishable with death or with transportation or with imprisonment for a term exceeding 10 years. Sentences with High Court divisions and session judges may pass. The High Court division may pass any sentence authorized by law. A session judge or additional session judge may pass any sentence authorized by law, but any sentence of the death passed by any such judge shall be subject to confirmation by the High Court division. A joint session judge may pass any sentence authorized by law except a sentence of death or a transportation for a term exceeding 10 years or of imprisonment for a term exceeding 10 years. Sentences which magistrates may pass. The courts of magistrates may pass the following sentences, namely, courts of Metropolitan Magistrate and of magistrates of the first class imprisonment for a terms not exceeding 5 years, including such solitary confinement as is authorized by law. Fine not exceeding 10,000 taka, whipping courts of magistrate of the second class imprisonment for a term not exceeding 3 years, including such solitary confinement as is authorized by law. Fine not exceeding 5,000 taka. Courts of magistrates of the third class imprisonment for term not exceeding 2 years. Fine not exceeding 2,000 taka. The court of any magistrate may pass any lawful sentence combining any of the sentences which it is authorized by law to pass. Power of magistrate to sentence to imprisonment in default of fine. The court of any magistrate may award such terms of imprisonment in default of payment of fine as is authorized by law in cases of such default. Proviso as to certain cases. Provided that the term is not in excess of the magistrate's power under this code, in any case decided by a magistrate where imprisonment has been awarded as part of the substantive sentence, the period of imprisonment awarded in default of payment of the fine shall not exceed 1/4 of the period of imprisonment which such magistrate is competent to inflict as punishment for the offences otherwise than as imprisonment in default of payment of the fine. The imprisonment award under this section may be in addition to a substantive sentence of imprisonment for the maximum term awardable by magistrate under section 32. Higher powers of certain magistrates. The court of magistrate especially empowered under section 2090C may pass any sentence authorized by law except a sentence of death or of transportation of imprisonment for a term exceeding 7 years. Sentences in cases of conviction of several offences at one trial, maximum term of punishment. When a person is convicted at one trial of 2 or more offences, the court may, subject to the provisions of section 71 of the penal code, sentence him for such offences to the several punishments prescribed there for which such court is competent to inflict such punishments when consisting of imprisonment or transportations to commence the one after the expiration of the other in such order as the court may direct, unless the court directs that such punishments shall run concurrently. In the case of consecutive sentences, it shall not be necessary for the court, by reason one of the aggregate punishment for the several offences being in excess of the punishment which it is competent to inflict on conviction of single offence, to send the offender for trial before a higher court, provided as follows. In no case shall such person be sentenced to imprisonment for a longer period than 14 years. If the case is tried by a magistrate, the aggregate punishment shall not exceed twice the amount of punishment which he is in the exercise of his ordinary jurisdiction competent to inflict, for the purpose of appeal, the aggregate of consecutive sentences passed under this section in case of convictions for several offences at one trial shall be deemed to be a single sentences. Deduction of imprisonment in cases where convicts may have been custody. Except in the case of an offence punishable only with death, when any court finds an accused guilty of an offence and upon conviction sentences such accused to any term of imprisonment simple or rigorous, it shall deduct from the sentence of imprisonment the total period the accused may have been in custody in the meantime in connection with that offence. If the total period of custody prior to conviction referred to in subsection is longer than the period of imprisonment to which the accused is sentenced, the accused shall be deemed to have served out the sentence of imprisonment and shall be released at once, if in custody, unless required to be detained in connection with any other offences, and if the accused is also sentenced to pay in fine an additional such sentence, the final shall stand remitted. Ordinary powers of magistrates. All judicial and executive magistrates have the powers hereinafter respectively conferred upon them, and specified in 3rd schedule. Such powers are called their ordinary powers. Additional powers conferable on magistrates. In addition to his ordinary powers, any judicial or executive magistrate may be invested by the government or the chief judicial magistrate or the district magistrates, as the case may be, with any powers specified in the schedule 4, provided that the government may authorize the district magistrate to the investment in executive magistrate subordinate to him with any of its powers specified the schedule. Provided further that any judicial magistrate may be invested with such additional powers in consultation with the High Court Division. Control of district magistrates investing power. The power conferred on the district magistrate by the section 37 shall be exercised subject to the control of the government. Mode of conferring powers. In conferring powers under this code, the government may by order empower persons, especially by name or in virtue of their officers or classes of officials generally, by their official titles. Every such order shall take effect from the dates on which it is communicated to the person so empowered. Powers of officers appointed. Whenever any person holding an office in the service of the government who has been invested with any powers under this code throughout any local area is appointed to an equal or higher office of the same nature within a like local area, he shall, unless the government otherwise directs or has otherwise directed, exercise the same powers in the local area in which he is appointed. Withdrawal of powers. The government may withdraw all or any of the powers conferred under this code on any person by it or by an officer subordinate to it, provided that where the conferring of a power is under this code required to be made in consultation with the High Court Division, the withdrawal thereof shall be made in consultation with the court. Any powers conferred by the Chief Judicial Magistrate or the District Magistrate may be withdrawn by the Chief Judicial Magistrate or the District Magistrate respectively. Chapter 4. Of aid and information to the magistrates and the police and persons making arrests. Public when to assist. Every person is bound to assist any magistrate, either judicial or executive or police officer, reasonable demanding his aid in the taking or preventing the escape of any other person whom magistrate or police officer is authorized to arrest. In the prevention of suppression of the breach of the peace or any prevention of inquiry attempted to be committed to any railway, canal, telegraph or public property. Public to give information of certain offences. Every person aware of the commission of or of the intention of any other person to commit any offence punishable under any of the following sections of the Penal Code, namely 121, 120A, 122, 123, 124, 124A, 125, 126, 130, 143, 144, 145, 147, 148, 302, 303, 304, 320, 382, 392, 393, 394, 395, 396, 397, 398, 399, 402, 435, 436, 449, 450, 456, 457, 458, 459, and 460 shall, in the absence of responsible executes, the burden of providing which shall lie upon the person so aware of forthwith give information to the nearest magistrate or police officer of such commission and intention. For the purposes of this section, the term offence includes any act committed at any place out of Bangladesh which would constitute an offence of committed in Bangladesh. Village headmen, accountants, landholders, and others bound to report certain matters. Every village headman, village accountant, watchman, village police officer, owner or equipier of land, and the agent of any such owner or equipier in charge of the management of that land, and every officer employed in the collection of revenue or rent of land and on the part of the government or the court of wards shall forthwith communicate to the nearest magistrate or to the officer in charge of the nearest police station, whichever is the nearer, any information which he may possess respecting the payment, the permanent or temporary residence of any notorious receiver or vendor of stolen property in any village of which he is headman, accountant, watchman, or police officer, or in which he owns or occupies land, or is agent or collects revenue or rent, the resort to any place within or the passage through such village of any person whom he knows or reasonably respects to be a thug, robber, escaped convict, or proclaimed offender. The commission of an intention to commit in or near such village any non-bailable offense or any offense punishable under section 143, 144, 145, 147, or 148 of the Penal Code. The occurrence in or near such village of any sudden or unnatural death or of a death under suspicious circumstances, or the discovery in or near such village of any corpse or part of a corpse in circumstances which led to a reasonable suspicion that such a death has occurred, or the disappearance from such village of any person in circumstances which led to a reasonable suspicion that a non-bailable offence has been committed in respect of such person. The commission of our intention to commit at any place out of Bangladesh near such village any act which, if committed in Bangladesh, would be an offence punishable under any of the following sections of the Penal Code, namely 231, 233, 233, 234, 235, 236, 237, 238, 302, 304, 382, 392, 393, 394, 395, 396, 397, 398, 399, 402, 435, 436, 449, 450, 457, 458, 459, 460, 489A, 489B, 489C, and 489D. Any matter likely to affect the maintenance of order of the prevention of crime or the safety of person, property, respecting which the district magistrate by general or special order made with the previous sanction of the government has directed him to communicate information. In this section, village includes village lands, and the expression proclaimed offender includes any person proclaimed as an offender by a court or authorized, established, or continued by the government in any part of Bangladesh, in respect of any act which, if committed in Bangladesh, would be punishable under any of the following sections of the Penal Code, namely 332, 304, 382, 392, 393, 394, 395, 396, 397, 398, 399, 402, 435, 436, 449, 450, 457, 458, 459, and 460. Appointment of village headman by district magistrate in certain cases for purpose of this section. Subject to rules in this behalf to be made by the government, the district magistrate may from time to time appoint one or more persons with his or their consent to perform the duties of village headman. Under this section, either a village headman has or has not been appointed for that village under any other law. Chapter B of Arrest, Escape and Taking. Arrest how made. In making an arrest, the police officer or other person making the same shall actually touch or confine the body of the person to be arrested, unless there be a submission to the custody by word or action. Resisting endeavor to arrest. If such person forcibly resists the endeavor to arrest him or attempts to evade the arrest, such police officer or other person may use all means necessary to effect the arrest. Nothing in this section gives the right to cause the death of a person who is not accused of an offense, punishable with death or with transportation for life. Search of place entered by persons sought to be arrested. If any person acting under a warrant of arrest or any police officer having authority to arrest has reason to believe that the person to be arrested has entered into or is within any place, the person residing in or being in charge of such place shall, on demand of such person acting as aforesaid or such police officer, allow him free ingress thereto and afford all reasonable facilities for a search therein. Procedure where ingress not obtainable. If ingress to such place cannot be obtained under section 47, it shall be lawful in any case for a person acting under a warrant and in any case in which a warrant may issue, but cannot be obtained without affording the person to be arrested an opportunity of escape for a police officer to enter such place and search therein in order to effect an entrance into such place, to break open any outer or inner door or window of any house or place, either that of the person to be arrested or of any other person, if after notification of his authority and purpose and demand of admittance duty made, he cannot otherwise obtain admittance. Power to break open doors and windows for purposes of liberation. Any police officer or other person authorized to make an arrest may break open any outer or inner door or window of any house or place in order to liberate himself or any other person who, having lawfully entered for the purpose of making an arrest, is detained therein. No unnecessary restraint. The person arrested shall not be subjected to more restraint than is necessary to prevent this escape. Search of arrested persons. Whenever a person is arrested by a police officer under a warrant which does not provide for the taking of a bail, or under a warrant which provides for the taking of bail but the person arrested cannot furnish bail, and whenever a person is arrested without warrant or by a private person under a warrant and cannot legally be admitted to bail or is unable to furnish bail, the officer making the arrest or when the arrest is made by a private person, the police officer to whom he makes over the person arrested may search such person and place in safe custody all articles other than necessary wearing apparel found upon him. Mood of searching woman. Whenever it is necessary to cause a woman to be searched, the search shall be made by another woman with strict regard to decency. Power to seize offensive weapons. The officer or other person making any arrest under this code may take from the person arrested any offensive weapons which he has about this person and shall deliver all weapons so taken to the court or officer before which or whom the officer or person making the arrest is required by this court to produce the person arrested. When police may arrest without warrant. Any police officer may, without an order from a magistrate and without a warrant, arrest, firstly, any person who has been concerned in any cognizable offense or against whom a reasonable complaint has been made or credible information has been received, or reasonable suspicion exists of his having been so concerned. Secondly, any person having in his possession without lawful excuse the burden of providing which excuse shall lie on such person of any implement of house breaking. Thirdly, any person who has been proclaimed as an offender either under this code or by order of the government. Fourthly, any person in whose possession anything is found which may reasonably be suspected to be stolen property and who may reasonably be suspected of having committed an offense with reference to do such thing. Fifthly, any person who is obstructs to a police officer while in execution of his duty or who has escaped or attempts to escape from lawful custody. Sixthly, any person reasonably suspect of being a deserter from the armed forces of Bangladesh. Seventhly, any person who has been concerned in or against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists of his having been concerned in any act committed at any place out of Bangladesh which if committed in Bangladesh would have been punishable as an offence and for which he is under any law relating to extradition or under the Fugitive Offenders Act 1881 or otherwise liable to be apprehended or detained in custody in Bangladesh. Eighthly, any released convict communicating a breach of any rule made under section 565 subsection 3. Ninthly, any person for whose arrest or requisition has been received from another police officer provided that the requisition specifies the person to be arrested and the offence or other cause for which the arrest is to be made, and it appears therefrom that the person might lawfully be arrested without a warrant by the officer who issued the requisition. Arrest of vagabonds, habitual robbers, etc. Any officer in charge of police station may in like manner arrest or cause to be arrested any person found taking precautions to conceal his presence within the limits of such station under circumstances which afford reason to believe that he is taking such precautions with the view of committing a cognizable offense, or any person within the limits of such station who has no ostensible means of subsistence or who cannot give a satisfactory account of himself, or any person who is by repute an habitual robber, housebreaker or thief, or an habitual receiver of stolen property knowing it to be stolen, or who by repute habitually commits extortion or in order to the committing of extortion habitually puts or attempts to put persons in fear of injury. Procedure when police officer deputy subordinate to arrest without warrant. When any officer in charge of police station or any police officer making an investigation under chapter XIV requires any officer subordinate to him in arrest without a warrant, otherwise than in his presence, and any person who may lawfully be arrested without a warrant, he shall deliver to the officer required to make the arrest an order in writing specifying the person to be arrested and the offence or other cause for which the arrest is to be made. The officer so required shall, before making the arrest, notify to the person to be arrested the substance of the order, and if so required by such person, shall show him the order. Refusal to give name and residence. When any person who in the presence of a police officer has committed or has been accused of committing a non-cognizable offense refuses on demand of such officer to give his name and residence, or gives the name or residence which such officer has reason to believe to be false, he may be arrested by such officer in order that his name or residence may be ascertained. When the true name and residence of such person have been ascertained, he shall be released on his executing a bond with or without sureties to appear before a magistrate if so required, provided that if such person is not resident in Bangladesh, the bond shall be secured by a surety or sureties resident in Bangladesh. Should the true name and residence of such person not be ascertained within 24 hours from the time of arrest, or should he fail to execute the bond, or if so required to punish sufficient sureties, he shall forthwith be forwarded to the nearest magistrate having jurisdiction. Pursuit of offenders into other jurisdictions. A police officer may, for purpose of arresting without warranty and person whom he is authorized to arrest under this chapter, pursue such persons into a place in Bangladesh. Arrest by a private person and procedure on such arrest. Any private person may arrest any person who, in his view, commits the non-bailable and cognizable offences or any proclaimed offenders, and without unnecessary delay shall make over any person so arrested to a police officer, or in the absence of a police officer, take such person or cause him to be taken in custody to the nearest police station. If there is reason to believe that such person comes under the provisions of section 54, a police officer shall re-arrest him. If there is reason to believe that he has committed non-cognizable offences and he refuses on the demand of a police officer to give his name and residence, or gives the name residence which such officer has reason to believe to be false, he shall be dealt with under the provisions of section 57. If there is no sufficient reason to believe that he has committed any offences, he shall be at once released. Person arrested to be taken before magistrate or officer in charge of police station. A police officer making an arrest without warrant shall, without unnecessary delay and subject to the provisions herein contained as to bail, take or send the person arrested before a magistrate having jurisdiction in the case, or before the officer in charge of a police station. Person arrested not to be detained more than 24 hours. No police officer shall detain in custody a person arrested without warrant for a longer period than under all circumstances of the case is reasonable, and such period shall not, in the absence of a special order of magistrate under section 167, exceed 24 hours exclusive of the time necessary for the journey from the place of arrest to the magistrate's court. Police to report apprehensions. Officers in charge of police stations shall report in Metropolitan area to the Chief Metropolitan Magistrate, and in other areas to the District Magistrate, and also to the Chief Judicial Magistrate, the cases of all persons arrested without warrant within the limits of the respective stations, either such persons have been admitted to bail or otherwise. Discharge of person apprehended. No person who has been arrested by a police officer shall be discharged except on his own bond or on bail under the special order of a magistrate. Offence committed in magistrate's presence. When any offence is committed in presence of magistrate, either executive or judicial, within the local limits of this jurisdiction, he may himself arrest or order any person to arrest the offender, and may thereupon, subject to the provisions herein contained as to bail, commit the offender into custody. Arrest by or in presence of magistrate. Any magistrate, either executive or judicial, may at any time arrest or direct the arrest in his presence within the local limits of his jurisdiction of any person for whose arrest he is competent at the time and circumstances issue a warrant. Power on escape to pursue and retake. If a person in lawful custody escapes or is rescued, the person from whose custody he escaped or was rescued may immediately pursue and arrest him in any place in Bangladesh. Provisions of section 47, 48 and 49 to apply to arrest under section 66. The provisions of sections 47, 48 and 49 shall apply to arrest under section 66, although the person making any such arrest is not acting under warrant and is not police officer having authority to arrest. Chapter 6 of Process to Compel Appearance. Form of Summons. Every summons issued by a court under this code shall be in writing in duplicate, signed and sealed by the presiding officer in such court or by such other officer as the Supreme Court may from time to time by rule direct. Summons by whom served. Such summons shall be served by a police officer or subject to such rules as the government may prescribe in his behalf by an officer of the court issuing it or other public servant. Summons how served. The summons shall, if practicable, be served personally on the person summoned by delivering or tendering to him one of the duplicates of the summons. Signature of receipt for summons. Every person on whom a summons is so served shall, if so required by the serving officer, sign a receipt therefore on the back of the other duplicate. Service of a summons on an incorporated company or other body corporate may be effected by serving it on the secretary, local manager or other principal officer of the corporation or by registered post letter addressed to the chief officer of this corporation in Bangladesh. In such case, the service shall be deemed to have been effected when the letter would arrive in ordinary course of post. That's it for today. Thanks for watching. Subscribe our channel to see our next video. Thank you.